Are there any matters that we need to take up this morning prior to resuming the 30B6 deposition of Karen Brinson Bell?
No.
Your Honor, just one thing I wanted to clarify with the court on stipulations. On March 29th, the court received plaintiff's joint stipulations and defendant's joint stipulations, so two separate documents, but they were both joint. We don't believe they have been ordered into the record yet, so wanted to check with you to ensure that we were getting those stipulations into the record. And then also wanted to raise to your attention that we will be filing a first supplemental joint stipulation and would follow the same procedure for the original stipulations, assuming we can get that done to your satisfaction.
Were those joint stipulations included within the pretrial order?
That's a very good question, and I will.
Yeah, they were an exhibit to the pretrial order submission by the parties.
Okay. I signed the pretrial order, and that is part of the record in this case.
Okay.
So if they were included in the pretrial order, then I think your request has already been done.
Excellent. And then for the first supplemental stipulations, how would you like us to take care of those?
You can just file it with the court, and I mean, I'm not sure that the court needs to do anything as far as officially making part of the record. Joint stipulations, they are what they are. When you file them in the clerk's office, they become part of the record.
Okay.
I mean, I
Thank
don't
you.
know that I need to put my official stamp seal on it to make it official. If you file it, it's part of the record. It's joint stipulations of parties are included in the record, just like exhibits that are admitted into the record.
Thank you, Your Honor.
And Your Honor, there's nothing for the legislative defendants this morning. Thank you, Your Honor.
All right.
Nothing for the state. Thank you.
All right. I know Taylor Williams yesterday was the one sort of leading the deposition. I see Mr. Williams now appearing. Good morning, Mr. Williams. Can you hear me?
I can. Good morning, Your Honor.
All right. Are you ready to resume play of that deposition then?
We are, Your Honor.
Okay, then you may proceed.
Thank you.
And there were 2 cases of voter impersonation out of 4.8 million votes cast in the 2016 general election. Is that right?
That's what this report found, yes.
You don't have any reason to believe the report is inaccurate, do you?
No, I do not.
Do you have any basis to believe that these sort of numbers have increased or decreased substantially in subsequent elections since 2016?
Yes, state your question again, please.
Do you have any reason to believe that the statistics we just discussed about the numbers of voter impersonation cases have significantly increased or decreased in North Carolina since 2016?
We have, I don't know. There is not any particular, I don't know that I have a report prior to this, but since then, the cases are similar.
Taylor, could you please pull up tab 1? This is Exhibit 21, and it is a document that was produced by the State Board. It's dated March 11th, 2013. Do you see it?
I do, yes.
And this chart lists out documented cases of voter fraud in North Carolina from 2000 to 2012. Is that right?
That's right.
And you look about halfway down the chart, I'm sorry, it is a little bit blurry, but there's a line that says voting impersonation about halfway down. Do you see it?
I do.
And it shows there are 2 cases of voter impersonation, right?
That's right.
One in 2004 and one in 2012.
Yes.
That's broadly fairly consistent with the numbers we saw in the 2016 audit, right?
I would agree with that. Yes.
Taylor, could you please mark the 2015 to 2019 referred cases document? This is Exhibit 22, and it's a document entitled 2015 to 2019 NCSBE referred cases. And I'll represent to you, this is a document we pulled from the State Board website yesterday. Do you see it?
Yes, I do.
This is a chart of all the cases that were referred to prosecutors by the State Board between 2015 and 2019. Is that correct?
That's correct.
I'd like you to focus on the column that says impersonation of a voter. Do you see it?
I do.
And it, excuse me, it shows 2 instances in 2015, correct?
That's correct.
And 1 in 2016,
Yes.
1 in 2017,
Yes.
1 in 2018,
Yes.
and 0 in 2019,
Yes.
for a total of 5 in 5 years, correct?
Yes.
And if you look at the bottom right-hand cell, that lists out the total number of cases referred to prosecutors in that 5-year time period, correct?
That's correct.
And that's 570 cases.
That's right.
So all told, fewer than 1% of all the cases referred to prosecutors during this 5-year period were related to voter impersonation. Is that right?
Yes.
Do you know how many, if any, instances of voter impersonation are being investigated from the 2020 general election?
I don't know the specific number. We have a very small number of cases of these categories overall.
Would it be, consistent with numbers we've just been discussing, a handful, under 5?
That is my understanding. Yes.
So all told, is it fair to say that North Carolina has only seen a handful of cases involving voter impersonation over the past 20 years?
Provided that we quantify handful as the same, a small number, yes, is correct.
Okay. So you would agree a very small number of cases involving voter impersonation in the past 20 years?
Yes.
It is the position of the State Board that elections violations in North Carolina are not widespread. Is that correct?
Yes, that is correct.
Before December 19th, 2018, did any members of the General Assembly or their staff ask the State Board about any of the data we've just been discussing?
Before what date? I'm sorry.
December 19th, 2018.
2018. I don't believe there was anything beyond public records requests or other requests that we would have received.
Do you know of any specific public records requests that you received from the General Assembly about these issues?
Not that I'm aware
of. Do you know whether before December 19th, 2018, any members of the General Assembly or their staff asked the State Board for any data on incidences of voter fraud?
Not that I recall, or not that I'm aware of.
Is it your view that voter confidence is harmed by the knowledge that out of several million votes cast, 1 or 2 votes might be ineligible?
I'm sorry, state that one more time.
Is it your view that voter confidence is harmed by the knowledge that out of several million votes cast in an election, 1 or 2 of those several million votes might be ineligible?
Yes, I've stated something to that effect.
So would you agree that voter confidence is harmed by anything less than a completely perfect system?
I think that I don't think we can have a perfect system, but I do think that inflation of instances or misinformation about instances does harm voter perception and voter confidence.
When you say inflation of instances, do you mean a perception that there are more ineligible voters voting than there actually are?
I'm referring to statements that have been out on social media and other platforms that imply that there is rampant voter fraud or rampant illegal voters voting, things of that nature.
So it's your view that statements suggesting there's rampant voter fraud undermine voter confidence. Is that right?
I do agree with that. My personal view is that, yes.
And it's your view that there is not rampant voter fraud in North Carolina. Is that correct?
Are you asking as my personal view or organization view?
Organizational view.
We have stated as an organization as well that we do not believe there is rampant voter fraud in North Carolina or the nation.
But is it correct that simple fear of contracting COVID was an insufficient basis to vote curbside?
If that was their stated reason, but I believe what you read back is that if they had a condition that they feared would impact, I was trying to state that would further their condition, the fear of COVID would further their condition, then they were able to vote curbside.
I understand. I just want to clarify that I'm right that a simple fear of COVID would not have enabled them to vote curbside if there was not an underlying condition. Is that right?
If that is what they stated, then we were to say that that was not a disability or condition that would prohibit them from entering the polling place. But that would be how it would be handled.
Okay. With this sort of clarification, change your answer all to my question about the quote unquote other provision. So I'll restate it. If a voter does not have an underlying condition that makes them more vulnerable to COVID, but they're very afraid of it, and they write as their reasonable impediment that they are afraid of COVID and have been therefore isolating, don't want to leave their isolation to get an ID, do you have a view on whether that would count as other under the reasonable impediment declaration?
So I went on to further state that the line of other is open-ended, and therefore it's the decision by the County Board of Elections to determine if there is anything false about what they stated. It doesn't, we have not, other is broad and open-ended, so the boards would have to unanimously decide that there was something falsely stated. So that's how I would interpret where the decision of what can be accepted in other.
And it's up to the county boards.
Well, yes, I mean, that's where the decision's made about these affidavits.
Hello, Ms. Bell. It's nice to see you again.
Good to see you.
As you know, my name is Nicole Moss, and I am one of the attorneys for the legislative defendants in this matter. Hopefully, I won't have too many questions for you, but I did have a couple of areas I wanted to get into some more specifics with you about. Well, while I'm getting my copy of that law so I can screen share it with you, Ms. Bell, let me ask you this. Do you know, are the requirements for getting a free ID from the DMV, do those differ in any way from the requirements to get a free ID from one of the county boards of election?
Yes, there are differences between what the free ID that's issued by the DMV versus what's issued at the County Board of Elections.
And can you describe for us what those differences are?
Well, even their purposes are different. A DMV issued ID is a non-operator license from the DMV. The ID that's issued by the County Board of Elections is specifically a voter ID, and that is only for the purposes of voting.
And those are the purposes. In order to obtain the ID, are there different documents that have to be shown?
Yes, as I recall, there are. An individual who was going before the DMV had to have a record of birth, as I recall. Date of birth is stated to the elections office. there's a statement of information to the elections office, date of birth, social security number. At the DMV, the document had to be provided, and I also recall, and I believe it's still in effect, that they had to determine if the first person was a registered voter or not. Okay. We would do that at the County Board of Elections as well, but that's an additional step that the DMV would not have within their system.
So no documentation required in order to get the free ID from the County Board of Elections, but a voter would need to bring documentation with them to the DMV.
That's correct.
Would a voter who was voting during early voting be able to obtain a free ID from the County Board of Elections and vote with that ID that same day?
Yes, yes, we did put that in place.
Would you defer, for example, to Brian Neesby if there was questions about an analysis that was done regarding data matching?
I would. He would be one individual I would turn to, yes.
And has the board done any analysis of whether or not needing to use the reasonable impediment process because a voter lacks an acceptable ID would deter a voter from voting?
There's not been an analysis to my knowledge either way about that.
So the board doesn't have any data indicating whether or not that would be a deterrent to a voter?
There has not been an analysis done to my knowledge.
Okay. Does the board have any data indicating that any registered voters would opt not to vote rather than obtain a free ID issued by one of the county boards of election?
The state board has not done an analysis about that to my knowledge.
Have you received any information from any source that would suggest that that is a possibility?
Not that I'm aware of.
Ms. Morton asked you several questions about the reasonable impediment process that was in place under House Bill 589 during the one election when I believe it was in effect, which was the March 2016 primary. Is that right?
Yes, I will say that I've tried to recall whether we also had a special congressional election or the date was moved on the congressional election that year. So I believe it may have been in effect then. So I may have misstated earlier, but I'm not specific. I'm not certain of that. I have not confirmed it.
Okay, so it's possible it was also in effect during a very limited election that may have taken place in June of 2016, and that was not a statewide election. Is that right?
I don't recall whether that would have been
okay.
It would have been a congressional election. I'm trying to recall. I haven't researched because we're in deposition, but there may have been use of it in June for congressional elections. Whether those were all the congressional districts or not, I don't actually recall.
Do you know how the turnout in the March 2016 primary compared to prior presidential election year primaries?
I believe it was in line with other presidential years. I was actually working at a precinct that year, so I don't recall the whole statewide.
Okay. So you don't know whether turnout was higher or lower?
I believe that over the past few presidential elections, it has been consistent until this year, which is substantially higher.
In those requests for admissions, the state board provided a number of votes that were cast in the March 15, 2016 primary. Do you recall indicating in those admissions that 2,332,045 votes were cast? So about 2.3 million?
Yes, that sounds right.
Does that sound right to you? Okay. So would you agree that 1,048 voters out of 2.3 million is a small number?
Proportionally, that is a small number, yes.
And of those 1,048 voters who completed a declaration of reasonable impediment, how many were the legislature told ultimately had their vote counted?
In this presentation, it was 864.
Let me clarify, a reasonable impediment ballot or a ballot accompanied by a reasonable impediment declaration can it be rejected for any reason other than falsity?
No, not a reasonable impediment.
Let me ask you this. What is your understanding of what the largest college or university system is in North Carolina?
University system?
Yes.
I assume you're referring to the UNC system?
Okay. And has the UNC system had its student IDs approved by the State Board of Elections for purposes of voting?
There have been UNC system IDs approved, yes.
Do you have any reason to believe that the county boards of election and their staff will not work in good faith to appropriately implement this law if the injunction is lifted?
We are election professionals and election administrators. We administer the law as it is written and is in place. So I have no doubt that whatever the law is what we will administer and implement.
Do you have any reason to believe that any of the counties will implement the reasonable impediment process in a way that would intentionally discriminate against any minority group?
I do not have reason to believe that they would do that, no.
Do you have any reason to believe that the state board would not be capable of implementing appropriate training in order to make sure that Senate Bill 824 could be implemented in a fair way?
We were prepared to implement 824 and offer the training necessary prior to the injunction and would do so if the injunction were lifted.
And if you were to move forward, or if you were able to move forward with implementing Senate Bill 824, would you do so in a way that would be race neutral?
I'm not sure if I understand your definition of that terminology, but I will answer that. You know, our profession, our job is to implement the law as it is written or allowed, and you know, we also ensure that any eligible voter is able to cast their ballot.
And similarly, do you have any reason to doubt that the county boards would follow the State Board of Elections guidance and directives to enforce the requirements in Senate Bill 824 in a, race neutral, non-discriminatory way?
I have no reason to think that they would not do so.
Do you believe that every incident of voter fraud is reported to the State Board of Elections for investigation?
I think I would have to answer no, but I don't think that there's I would just answer no.
Do you know what, if any, efforts the State Board of Election makes to determine whether any double voting occurs across state lines? So in other words, somebody who would register to vote in North Carolina and vote here, but also vote in another state's election?
The state used to participate in the interstate cross-check, which is no longer in existence. I have recommended to the legislature that we participate in ERIC, which is a long-standing system that more than 30 states participate in, and I have not received the funding to move forward with that.
Okay. And so previously you participated in this cross-check system. And when is the last time that the state looked at cross-check data?
I believe it was 2016. I don't believe it was done in 2018, but I'm not, would not say that I'm certain of that one.
Okay. And that, and then the ERIC system, those are looking more specifically at double voting across state lines. Is that a correct understanding?
That is one facet. It is trying to establish a line of communication across state lines.
I understand that. My question was separate. It was if there was an incidence of potential double voting identified and it was being investigated, do you believe that having photo ID requirements in place in those states would help assist in that investigation?
I don't know whether it would or not. I mean, the photo ID is presented at the time of voting, and an investigation would be post-voting.
Will the inclusion of the public assistance IDs in the voter ID law, will that make it more difficult for minorities to vote?
I don't know that it's a question of whether it makes it more difficult for a minority or someone not in the minority to vote. I mean, it would be another form of ID that would be available.
And is there any reason, going back to asking you this in your state board capacity, is there any reason to believe the inclusion of public assistance IDs would have an adverse impact on minority turnout?
I don't know that we've not had a position one way or the other on that.
Okay, and do you understand this to be a copy of SB 824 as enacted?
Yes, that's understanding.
And after having reread this, let me first establish, you've read this bill before, right?
Yes.
And after having reread this section, does it refresh your recollection as to whether the law actually changed the provisions that would allow for the DMV to issue free IDs? Specifically that, it changed one of the ways that you could get an ID from being someone over the age of 17 to someone over the age of 17.
That's right. And then it struck some areas, as you can see in items 5 and 6.
Right. And so sitting here today, do you have any reason, or do you have any knowledge as to how these changes in the requirements for DMV to issue free ID have altered in any way the frequency with which DMV is issuing free IDs?
I know they continue to issue them, and I have had some discussion at times about the aspect of the homeless individual seeking an ID. But I'm not, I don't recall the frequency right now. I know that there are still IDs still being issued.
You don't have any information at your fingertips right now as to how many free IDs have been issued in total from DMV since VIVA was enacted?
I don't have it in front of me now. I have seen that information, and I know it's continued to go up, but I don't have that information in front of me.
Okay, just establishing for the record, you don't actually know what the rate of ID issuance is from the DMV for free IDs.
I don't know, not.
Turning now to a line of questioning from Ms. Morton on how much time it may take the state board to prepare to implement SB 824 if an injunction were lifted. Do you recall that line of questioning?
I do.
And to determine for sure how much time it would take for the state board to prepare to enforce photo ID in an election if an injunction were lifted, would you need to consult with various staff members at the state board?
Oh, absolutely. Yes.
And you may need to review some data and some additional facts about or where the staff are in certain processes.
Yes, I recall, I think I even wound up saying that I needed to put pen to paper to make sure that I understand what time frame we would need to work under. There's considerations particular to our SEAMS development that would have to be factored in if there's any changes to that and the time frame that we're working under with SEAMS, and depending on what elections being when it would go into effect. If it's the municipal elections, then we have municipal elections that take place in September, October, and November. So that could affect the time frame that I would have to establish.
And you haven't done any of that inquiry yet, have you?
No, we have not.
So,
We're
so you're
conducting this election, so I haven't moved to the next one.
so your answer earlier should not be taken as a definitive response on behalf of the agency as to this particular issue, as to how long specifically it's going to take to be prepared to implement photo ID.
Yeah, I was not trying to be definitive. I have not determined, nor have I determined with staff as to exactly how long. And there are a variety of factors depending on if we would be required to do any of the work that's been done before, such as the seminars, webinars, excuse me, not web, no, I guess they would be webinars at this point, but nonetheless, the seminars that were conducted by the training staff in the counties, for example.
Ms. Bell, I have just a few questions for you right now. Do you recall when Ms. Moss asked you a few minutes ago if you believe that every instance of voter fraud was reported to the state board?
I do.
Are you aware of any specific incidences of voter fraud that were not reported to the state board?
I'm not aware particularly. That was a very hard question to answer.
And it's still your view, correct, that voter fraud in North Carolina is not widespread?
That is still my view, yes.
Do you recall when we looked at the 2017 post-election audit report?
Yes.
And we discussed that there were 24 cases of double voting in that report?
Yes.
And 2 cases of voter impersonation?
That's correct.
So there were 12 times the number of cases of double voting as voter impersonation in the 2016 general election. Is that right?
Yes, that's math I can do. Yes.
And you testified earlier in speaking with Ms. Moss that you believed that ERIC might help combat against double voting problems. Is that correct?
Yes, I think we would benefit from ERIC, and that would be one of the reasons.
And that the state board has therefore requested funding for ERIC from the state legislature. Is that correct?
That's correct.
And the state board has not provided funding for ERIC, correct?
The state board has not provided.
I'm so sorry. Thank you. The state legislature has not provided funding for ERIC.
Yeah, I have indicated that that is an objective that we would like to pursue, and that funding has not been designated.
But the state legislature has designated funding for voter ID, correct?
Through 824, yes, there was money allocated to photo ID.
Even though there are 12 times as many cases of double voting as voter impersonation?
That, based on this report, yes.
Mr. Williams, is that the conclusion of that witness?
Yes, Your Honor, that concludes the deposition video of Director Bell.
All right, Ms. Riggs, I understand that we've still got to finish Joel Ford's testimony. And understanding our conversation yesterday that we're not requiring you to rest and not putting you in a position of resting until you finish your evidence, and obviously you'll have the chance to introduce further exhibits as well. Do you have any other evidence right now that you want to present before we proceed with taking, out of order, yes, without prejudice to you, Keegan Callinan's testimony?
No, Your Honor, we do have some exhibits to move in, but we think it makes sense to just do it before we rest our case tomorrow.
Okay. Mr. Thompson, are you prepared to call the legislative defendant's first witness then?
Yes, Your Honor. The legislative defendants would like to call Professor Keegan Callanan, that will be handled by Mr. Patterson with the court's permission.
All right. Who will be cross-examining this witness on behalf of the state defendant?
Paul Cox, Your Honor.
And who will be cross-examining this witness on behalf of the plaintiff?
Paul Brockman, Your Honor.
Okay. Can we let Keegan Callanan in the courtroom? Can Keegan Callanan hear me? I see Mr. Callanan. Mr. Callanan, can you hear me?
I can hear you now. Yes, Your Honor.
Okay, great. Would you please raise your right hand? Madam Clerk, could you please swear in Mr. Callanan?
Do you solemnly affirm that your testimony to the court will be the truth, the whole truth, and nothing but the truth, and this is your solemn affirmation?
I do.
Thank you. You can lower your hand.
Mr. Patterson, you may examine the witness.
Thank you, Your Honor. This is Pete Patterson for the legislative defendants, and good morning, Professor Callahan.
Good morning, Mr. Patterson.
Professor Callahan, I'd like to start with some questions about your background. Could you please describe your academic training for the court?
Sure. Well, my bachelor's degree is from Bowdoin College. It's in government. And my graduate training was at Duke University. So I obtained a master's in political science from Duke University and a PhD in political science from Duke University. And then from there, I had a postdoctoral fellowship in the program on constitutionalism and democracy within the Department of Politics at the University of Virginia.
Okay, and what academic positions have you held since completing your PhD?
So my first academic position was at the University of Virginia as a teaching fellow in the Department of Politics. I then moved to Middlebury College in Vermont, which is my current primary appointment. I began as a visiting assistant professor and then was promoted to a tenure track assistant professor and finally an associate professor with tenure in Middlebury College's Department of Political Science, where that's my current primary appointment. I also serve as at Middlebury College as the director of the Alexander Hamilton Forum on the American Political Tradition. And concurrently with my appointment at Middlebury, I served from 2017 to 2018 as a visiting fellow in the James Madison Program on American Ideals and Institutions at Princeton University within the Department of Politics there. And I currently am a visiting fellow in the current academic year, so 2020 to 2021, in the Department of Politics at Princeton University.
And what are some representative courses that you have taught?
I taught a number of courses over the years. Some representative ones would be the American Political Tradition, Left, Right, and Center, Statesmanship and Modern Liberty, Introduction to Political Philosophy.
And in any of your courses, do you teach about voting rights in the United States?
I do. I teach about voting rights, Jim Crow, and the relationship between civil, political, and economic rights, and the experience of African Americans in particular in the United States. That's within my course on the American political tradition, for example. But of course, in other courses, the fundamental questions of rights of participation come up multiple times.
And in any of your courses, do you teach about norms and their development?
I do.
And What professional associations have you been a member of?
I've been a member of the American Political Science Association, the Northeastern Political Science Association, Southern Political Science Association, the Western Political Science Association, and the New England Political Science Association. I served for 2 years on the executive board of the New England Political Science Association.
And what are some of your main areas of research?
They would include democratic theory, political culture, modern political thought, foundations and origins of American political institutions.
And have you published peer-reviewed works in your field?
I have. I've published journal articles in peer-reviewed journals. I've also published a peer-reviewed book with Cambridge University Press in political science. I'm currently at work on a book that is under contract with Cambridge University Press.
And have you served as a referee for academic journals?
I have. I've served as a referee for journals like the American Political Science Review, the Journal of Politics, Polity, Review of Politics, among others.
Has your academic work and training included examining and evaluating political science literature?
Yes, that's fundamental to my training, my teaching, my research.
And have you scientifically studied democratic political institutions, legislative processes, and procedures?
I have.
And have you studied norms and the process by which they are established?
I have.
Your Honors, we tender Professor Keegan Callanan as an expert in political science on the basis of his knowledge, skill, experience, training, and education.
Your Honors, plaintiffs would like the opportunity to conduct a brief voir dire.
Okay, you may proceed with a brief voir dire.
Thank you, Your Honor. Good morning, Professor Callanan. We've met before. It's good to see you again. But for the record, my name is Paul Brockman. I'm one of the lawyers for the plaintiffs in this case, and I have just a few questions for you. I think you testified a moment ago that your areas of research specialization include democratic theory, political culture, and the origins and development of American political institutions. Is that correct?
That's correct.
And you've published on Montesquieu and on Alexander de Tocqueville's book, Democracy in America. Is that correct?
Yes, I have.
Montesquieu is an 18th century French philosopher, right?
That's correct.
And if I'm recalling my undergraduate days correctly, Democracy in America focused on United States politics in the 1800s. Is that correct?
That's correct. That's the focus of Tocqueville's book, yes.
Okay. And your published research and writing that you discussed with Mr. Patterson a moment ago does not evaluate the efficacy of voter ID laws. Is that correct?
It does not. It's my research is within the area of democratic theory, which includes the study of democratic political institutions, processes, and principles. Certainly within that area of expertise, election regulations and administration would fall, but I've never published specifically on voter ID.
Okay, including the design of voter ID laws as well?
That's correct.
And your published research and writing also does not focus on incidences of voter impersonation fraud. Is that correct?
Yes.
And your scholarship and published work likewise do not focus on the North Carolina legislature or norms within the North Carolina legislature specifically. Is that correct?
That is correct.
Okay, and I think the last time we spoke, you were not actively working on any scholarship or research in the areas that I just described. Is that still accurate?
Nothing in draft.
Okay, and you're also not doing any teaching on the subject of ID possession rates amongst the voting age population. Is that correct?
That's correct.
And rates of ID possession is not a subject of your scholarly research and publication, correct?
Could you repeat the question? I'm sorry.
Of course. Rates of ID possession amongst the voting age population, that is not a subject of your scholarly research and publication. Is that right?
That's correct.
Okay. And you do not teach courses in statistics, do you?
That's correct.
And you don't teach courses on methods of quantitative analysis either?
But certainly the questions of quantitative analysis arise in my courses, but I don't teach any courses that are training students in the specifics of undertaking quantitative analysis.
Okay. And you have not published any peer-reviewed articles where you present your own statistical research or quantitative analysis on voter behavior, have you?
Mr. Brockman,
No.
I hate to interject, but the witness was tendered as an expert within political science, and it appears to me that most of these questions can be handled on cross-examination, and that none of the questions that you asked so far go to whether or not he is qualified to testify as an expert within the field of political science. So can you tell me the nature or the grounds upon which you object to the legislative defendant's tender of this witness? And I'll hear you on that first, and then I'll hear you on specific questions that you'd like to ask that go to that tender.
Happy to, Your Honor. We do not dispute Professor Callinan's qualifications as a political scientist. However, we think that his opinions on the design, comparative design and efficacy of specifically voter ID legislation, as well as his opinions on the impact of voter ID legislation on voter behavior and voter confidence, are not covered by a general expertise in political science, and that, as I've tried to demonstrate through these questions in voir dire, his research and areas of teaching and publication do not provide a basis for an expert qualification on those opinions.
It seems to me that those questions can be handled on cross-examination. And it doesn't sound to me like you have a specific objection to the plaintiff's tender of this witness in the field of expertise which they have proffered. And so unless you have a specific objection as to the tender of this witness as an expert within the field of political science, then it sounds like you have no objection to their tender. The purpose, in my mind, of a voir dire is to challenge the legislative defendant's tender of this witness in an expert within the field for which they purport he has specialized skill or knowledge. It sounds like some of the arguments that you're making now or intend to make perhaps go to the weight of the evidence and perhaps not of its admissibility, number one. And number two, you certainly will have the right to object to this witness's testimony during his direct examination if you believe that his answers or the questions are outside his field of expertise. Am I wrong in that?
Your Honor, we're happy to reserve our objections to the extent that we believe an opinion exceeds beyond the scope of general expertise in political science.
Okay, let's do that then, and let's allow Mr. Patterson to examine the witness. Mr. Patterson, you may ask your next question.
Thank you, Your Honor. I would like to pull up JX25, and this is a June 18th, 2019 affidavit submitted by Professor Callanan. And Professor Callanan, do you see on the screen here, this is labeled Affidavit of Keegan Callanan, PhD?
I do.
And do you recognize this as the affidavit that you submitted on June 18th, 2019 at the preliminary injunction stage of this case?
I do.
Let me stop just 1 second. One thing that I got caught up in there and that I forgot to do was receive the witness as an expert within the field that he was tendered. So he is so received as an expert within the field of political science. I'm sorry to interject. You may ask your next question.
No, Your Honor, I am glad that you interjected that. So I would like to bring up now JX25, 26, which is another affidavit submitted by Professor Callanan, this one dated December 14th, 2020. And Professor Callanan, do you recognize this as the affidavit that you submitted, or the expert report that you authored at the merits stage of this case?
I do.
Okay, great. And then one more. This is JX27, and this is a January 20th, 2021, another affidavit submitted by you, Professor Callanan. And do you recognize this as the rebuttal report you prepared at the merit stage of this case?
I do.
Okay, I'd like to turn to paragraph 38 of this report, and in particular a footnote number 40 at the bottom of that page. Okay, we have that up on the screen now. Does this footnote correct a mistake in the PI report that we had pulled up, JX25, a moment ago?
It does.
Other than what is reflected in this footnote, do you wish to make any additional corrections to any of your reports?
I do, and actually the correction is to this page. So I write about midway through footnote 40, I write, Ms. Ferris's report overstates the number of days elapsed between the introduction and ratification of SB 965 and SB 577 because she mistakenly uses the governor's signature. Mistakenly uses the date of the governor's signature rather than the date of the General Assembly's ratification as the terminal date in her calculation of days between introduction and ratification. Ms. Ferris has since confirmed that her report does contain these two errors, mixing the governor's signature date with the ratification date. However, she's also flagged a third error in her table, another small error in her table, whereby she set the introduction date of SB 577 too late. And so as a result of this third mistake, it's now clear to me that Ms. Ferris overstates the number of days that elapsed between introduction and ratification of SB 965 and understates the number of days elapsed between introduction and ratification for SB 577. Again, all three of these, the two that I identified and the one that she identified, are minor mistakes. The implication of the third error is that one data point in this footnote has to, two data points in this footnote have to change. One is that I find, actually on this page, one is that I report that a third, 33% of bills since 33% of bills since 1985 have proceeded in under 2 months. And that number, 33%, needs to move to 29%. I also report that 40% of constitutional amendments have moved to ratification since 1971 in under 2 months. And that 40% needs to move to 38%. So those are two small changes that don't affect my conclusions that are the result of this third error, which I had missed in the table from Ms. Ferris's report on which I relied.
Okay, and just to be clear, I believe you just said it, but these changes don't affect your ultimate conclusions that you're presenting the court in this case, correct?
That's right.
And do the three documents we have just looked at express the opinions you intend to offer in this case?
They do.
Your Honors, we move to admit JX25, JX26, and JX27 into evidence in this case pursuant to the stipulation of the parties as Professor Callanan's direct testimony.
AX 25 through 27 are received. Thank you.
Okay, thank you, Your Honor. Professor Callanan, at a high level, how would you describe the issues you address in your testimony in this case?
I addressed the process by which SB 824 and HB 1092 were enacted. I compare the structure of SB 824 to other voter ID laws, and I assess the bases of certain interests that the state has asserted with respect to SB 824.
Okay, and let's turn first to process, which is the first category that you had mentioned. And we'll start with HB 1092, which was the legislation putting the voter ID constitutional amendment on the ballot. In your opinion, to what extent was it consistent with normal legislative practices to enact HB 1092 in a short session?
So 25%, over 25% of constitutional amendments have been ratified by the General Assembly in the short session. So HB 1092 ratified in the short session puts it in company of over 25% of other constitutional amendments. In May of 2017, the United States Supreme Court, as we're aware, denied cert in litigation over 589. So it's not until May, late May of 2017, that legislators are aware of what the outcome, the final outcome of that litigation is. So if we assume that they know what they want to do from a policy point of view with respect to voter ID, and I don't know whether they knew what they wanted to do from a policy perspective at that point. But if we assume that they knew what they wanted to do from a policy perspective, they would have a couple of options. One would be that they could move quickly to introduce voter ID legislation within a month or a couple of months from the end of litigation in 589. Another option that they would have would be to wait a year, and they waited a year. Given this fact of this late-breaking Supreme Court decision or denial, it's not surprising to see, it's particularly unsurprising to see 1092 dealt with a year later in the short session, enacted in the short session as 25% of other constitutional amendments have been enacted.
Okay, and now moving to the situation of November of 2018. Before November of 2018, how many times in North Carolina history had a party lost a supermajority in the General Assembly while the governorship vested with power of veto was held by a member of a different party?
It had never happened before in North Carolina history. And in fact, it couldn't have happened before 1996 because the governor was not vested with power of veto before 1996. So you had an entirely different separation of powers dynamic prior to 1996. This major constitutional change, North Carolina becoming the last state in the union to grant its governor power of veto.
And in evaluating the process of enacting SB 824, why is it relevant that this particular set of circumstances had never happened before in North Carolina history?
I find it relevant because what it means is that you have a limited number of comparators, close or similar comparators to the situation that the General Assembly finds itself in the lame duck period of 2018. Which is to say you only actually have one other one other situation in which the General Assembly, or let's say a legislative majority in the General Assembly, is on the cusp of facing a hostile veto pen come January. And that is in 2016. This is the only other time in North Carolina history, again, that a legislative majority during the lame duck is on the cusp of facing the veto pen of the opposite party come January. And so this suggests us that this would be the comparator to look at if we wanted to ask the question, how does the North Carolina General Assembly behave in situations like this? What's the range of normal behavior for the General Assembly of North Carolina when it's similarly situated? And if we look in 2016, what we find is that the General Assembly called a lame duck session. In fact, they called the first extra session by legislative proclamation ever called in the lame duck. They legislated in that session. They passed an omnibus and then another bill with multi-purpose bill. These bills covered 7 or 8 different topics, and both passed in the lame duck. And from introduction to ratification, only 3 days elapsed. So the distinctiveness of the situation in 2018 makes it most directly analogous to the situation in the distinctiveness of the situation in 2018 makes it most directly analogous to the situation in 2016, and it suggests that that comparator would be the most interesting if what we were looking for was the legislatures when similarly situated. It also is relevant that the legislature is in this situation only in an analogous situation only one previous time, because it suggests it could be useful to look outside of the North Carolina example if we want more comparators of legislative institutions with similar institutional constraints that are similarly situated, and we want to ask, how do they act in situations like this?
Okay, and what are some other sources outside of North Carolina that you think are useful to be considered in this circumstance?
Well, we could look at the behavior of other American legislators who are operating within similar institutions under similar constraints, which is to say, power shifting elections in which you have a distinctive set of incentives that don't exist in the normal, part of the biennium. So, for instance, we could look at other state legislatures whose rules allow lame duck sessions. Now, not all state legislatures have rules like North Carolina's that allow lame duck sessions. But among those that do have rules that allow lame duck sessions, we find that it is common to legislate in the lame duck. And we also find instances of legislating in the lame duck following a power shifting election. I give an example that's particularly striking from Illinois, in which you get civil unions, the abolition of capital punishment, and the largest tax increase in Illinois history because of a power shifting election, all in the lame duck. But you can also look at the United States Congress, which is institutionally similar to the General Assembly, not identical, but institutionally similar. If we want another comparator with lots of data in which we can ask, well, how do legislators behave there differently in the lame duck versus outside of the lame duck, and particularly following power shifting elections? And what we find is interesting. We find that first of all, we find that lame duck sessions have been called every single time there's been a power shifting election since 1954 by the United States Congress. Every time you've got a power shifting election, a lame duck session is called. We find that the pace of action in these lame duck sessions is radically different from the pace of action outside of these lame duck sessions. The average time to passage for a non-trivial bill outside the lame duck is over 200 days. in the period that I examined in the United States Congress. In the lame duck, 200 days becomes about 20 days. So about 10 times faster a pace of action in the lame duck as opposed to outside the lame duck in the United States Congress. A very significant percentage of bills you find being passed in less than 10 days. I have the number in my report. So it's useful to look outside of the context of North Carolina, given the fact that we really don't have many comparators in North Carolina that are certainly, I think only one that's directly analogous. But because the veto is so late, even fewer than we would find in other legislative bodies.
Building on that answer, one follow-up question is that given that the General Assembly in 2018 was acting in a lame duck session to enact SB 824, to what extent can one determine whether the time the General Assembly took to enact SB 824 was aberrational by looking at past actions of the General Assembly in non-lame duck sessions?
I would say that to a very limited extent could you make any judgments without looking at the non-lame duck session, because that kind of analysis is not context specific. It abstracts from context and essentially proceeds on the assumption that we should expect rational actors to act the same under radically different constraints. And that is not certainly consistent with a basic rational actor model of politics as you find predominant in the field of political science. What we actually expect is for actors in significantly different choice situations to behave differently. And so this is consistent with what we find, as I've mentioned, you find a much higher pace of action, for example, a much faster pace of action in the United States Congress in the lame duck. And again, if we only want to stick with North Carolina precedents, we have the precedent. It's 2016, the only time the legislature, or it's the closest analog to the current. And what they do is they legislate in 3 days. So that would be the reason, that's I think a summary of a reason why you must consult context if you're asking the question, what should we expect? What's within the range of expectation for legislatures similarly situated?
And to what extent was it aberrational for the General Assembly to have enacted a voter ID bill in the lame duck session in 2018 rather than waiting for the following year?
So we could think about this two ways. We could think about it from the point of view of a rational actor model of politics and ask, do political scientists expect rational actors to wait to move on policy objectives until they're in a weaker political position, a weaker position with respect to power? Or do we expect them, is it normal for them to act when they're in a stronger position? And a rational actor model would certainly yield the expectation that they're going to act when their power is at its zenith rather than when it's at its nadir. But you can also, if you want to stick just with North Carolina precedents, you can think about it that way too. So that's the hypothesis. The hypothesis is what's normal in North Carolina would be to wait until the next year to pass implementation legislation for HB 1092. Well, we could ask the question, in the past, when the General Assembly has had a constitutional amendment that required implementation legislation, have they ever waited until the next biennium? Have they ever waited until the next legislature was seated prior to 2018? And the answer is no. In the two previous examples that Ms. Ferris cites, they passed implementation legislation within the biennium, which is exactly what the legislature did in 2018. So either if you want to look at it narrowly in terms of prior North Carolina precedents, or if you want to take a broader view and think about the rational actor model, from neither of those lenses, is it surprising that the legislature acted in the lame duck?
I'm sorry. Your internet blipped and you said, if I can just repeat what I heard, and then I didn't hear the rest. You think about the rational actor model from neither of these, and then I could not hear you.
I was saying that either, whether you want to think about what's normal narrowly in terms of, the two other instances in which the North Carolina General Assembly had ratified and had approved by the voters a constitutional amendment that required implementation legislation, or if you want to think about this from a broader point of view of what we expect of rational actors. From neither of those points of view is it surprising to see the General Assembly decide not to wait until the next biennium, until the next legislature is seated.
And I do see the professor's video is catching up a little bit. I think we'll continue to work with it, and if it's a problem, we can address it. But it's my understanding, Professor Callanan, that Governor Cooper's veto of SB 824 was the first veto of legislation implementing a constitutional amendment in North Carolina. To what extent was that veto aberrational, in your opinion?
I wouldn't regard it as aberrational. You would have to take a very narrow view of what counts as aberrational. And if you take the view that if anything happens, if anything happens for the first time, it's aberrational, then I think you'd have to call it aberrational. But if you ask the question, is it surprising to find a governor exercising the veto over a piece of legislation with which he strongly disagrees? That doesn't strike. I don't think that would strike any political scientist as surprising. It's perfectly consistent with a rational actor model of politics.
Given the situation facing the North Carolina General Assembly following the November 2018 election, to what extent was it aberrational for the General Assembly to have overridden Governor Cooper's veto of SB 824?
I would give the same answer for similar reasons. I don't find it aberrational for the General Assembly to have overridden the governor's veto. We find legislatures regularly overriding vetoes of legislation that they approved by large margins, margins sufficient to override a veto in the first instance. It's also the case North Carolina has an interesting distinction of the majority of vetoes being overridden in North Carolina history. So it's actually more common in North Carolina for a veto to be overridden than for it not to be overridden, at least as of 2018. And indeed, in the lame duck session, the General Assembly passed not only one bill that they eventually needed, for which they eventually needed to override a veto, but in fact they passed three bills that the governor vetoed and whose veto they overrode. So I find nothing beyond the range of expectation in that veto override.
You have mentioned Ms. Ferres a couple times thus far. You've considered the testimony that she's offered in this case. Is that right?
I have.
And what is your assessment of her opinion that the process by which SB 824 was enacted was aberrational?
Well, I think her definition of aberrational is so stringent that actually it's difficult to see how the General Assembly could have done anything that wasn't in her sense aberrational. So we could take the options one at a time. If the General Assembly had ratified SB 824 in the short session, along with 1092, this would have been the first time in North Carolina history that legislation required to implement a constitutional amendment had been ratified in the short session. They could have called an extra session for SB 824. But this would have been the first time in North Carolina history that an extra session had been called to enact implementation legislation required by a constitutional amendment. They could have waited until the next biennium, but that too, as I just said, would have been a first. So all of these alternatives would have been on Ms. Ferris's account, according to the logic of her report, as I understand it, aberrational. Moreover, if they had enacted SB 824 prior to the election, they would have been treating that implementation legislation differently than the way they treated the implementation legislation for the other constitutional amendments, which they decided to leave until after they knew whether the people had approved the amendment. So again, on a narrow understanding of what's aberrational, that would be aberrational from the other amendments. So it seems to me it's very difficult to make the case that that there was some other decision that they could have made, some other option available to them that would not be aberrational according to Ms. Ferris's standard.
And to what extent was the enactment of SB 824 a collaborative process in your view?
I call it collaborative in the report, and I cite several pieces of evidence that suggest that it's collaborative. I certainly don't assert that it's the most collaborative it could have been. It's not as if there were, an equal number of Democrats and Republicans voting for it, but it's collaborative in several senses. One is that you have a Democratic co-sponsor. Another is that you have 13 amendments adopted, roughly equal number in the House and in the Senate. And the majority of these amendments are sponsored by the minority party. You have about 20% of the Senate Democratic caucus that voting in favor of the bill. And you also have statements from Democratic legislators that suggest that it was a collaborative process. For example, you have Senator Ford saying that his sponsorship was not merely nominal, but in fact that he had, I think his language is, a significant influence in the crafting of the bill. And strikingly, you have Senator McKissick saying that the process had been open and inclusive. So these are not indicia of a non-collaborative process.
Now, are you aware of Ms. Ferris's criticism that you've overstated the extent to which the process of enacting SB 824 was collaborative?
I am aware of that criticism. I disagree, and she doesn't explain what is overstated. She just asserts that the process was. She just asserts that I had overstated that, but I saw nothing in her report that was specifically seeking to contradict any of the facts that I outline in that paragraph.
So I take it you don't wish to amend your opinion of the collaborative nature of SB 824's enactment on the basis of Ms. Ferris's statements. Is that right?
No.
And no, you do not wish to amend those opinions.
No,
right?
I do not. I do not wish to amend.
Okay, so that's the first item that you discussed in the reports that you've submitted. I'd like to now turn to the second, and that is a comparison of SB 824 to other voter ID laws. And in your understanding, how many states have voter ID laws?
34.
And overall, what do you conclude about SB 824 after comparing it to photo voter ID laws in other states?
I conclude in the report that it is non-strict with respect to its approach to voters who do not present ID. I conclude that it is relatively or moderately flexible in its approach to qualifying IDs. And I conclude that it is relatively accommodating in its approach to voters who lack and wish to obtain compliant ID.
Your Honors, plaintiffs would object here to this opinion as being outside the scope of Professor Callinan's expertise in political science. As I think covered during the voir dire, he does not conduct research or teach in the questions of the design of voter ID laws or the efficacy of such laws.
The objections overruled. You may answer the question.
Okay, and Professor Callanan, you may have already touched on this, but what factors did you consider in reaching these conclusions about North Carolina's voter ID law in comparison to other states' laws?
I considered what you could call the fail-safe options, so options that are within the structure of the law for voters who can't present ID. I considered the structure of the law with respect to compliant IDs, and then I also considered the provisions within the law for voters to obtain compliant ID.
Okay, and I'd like to pull up JX 873. This should already be in evidence. This is from the National Conference of State Legislatures. And this is their website on voter identification requirements and voter ID laws. And it's dated August 25th, 2020. Is this a document that you've considered in drafting your initial report in this case?
Yes.
And what is the National Conference of State Legislatures?
It's an organization of state legislators, a nonpartisan organization of state legislators. It's normally led by either a speaker of a house or a president of a state senate. And they perform various sorts of functions, one of which is producing data related to state legislatures and state level legislation.
And what was the purpose that you used this information for?
The organization has a classification system that classifies voter ID laws as photo, non-photo, and as strict, non-strict.
Okay, and if we could go down to page 5 of the PDF on this report, and just scroll down a bit more. So this table 1, is this basically a depiction of how the National Conference of State Legislatures classifies voter ID laws on those categories that you just described?
That's right.
Okay, and how does the National Conference of State Legislatures define a non-strict voter ID law?
So a non-strict voter ID law is a voter ID law that allows a voter who can't present ID to vote and have their ballot count without some further action, some action that they take after their visit to the polling station.
And how does the National Conference of State Legislatures define a strict voter ID law?
A strict voter ID law will only allow a voter's vote to count, a voter without ID will only allow their vote to count if they take some kind of additional action after their time in the polling station. And in the absence of that action, their vote will not count. So the example could be they may need to go and obtain ID and then bring it to the Board of Elections, or they may need to go get their ID at home and bring it to the Board of Elections. But there's no way for them to vote and have the vote counted all in one spot.
And to your knowledge, has the National Conference of State Legislatures changed these definitions of strict and non-strict voter ID laws in the time since you submitted your reports in this case?
No.
And have you checked since you submitted your report to confirm whether they maintain these definitions?
Yes.
And to what extent is this distinction that the National Conference of State Legislatures draws between strict and non-strict voter ID laws used in social science studying voter ID laws?
It's used in a number of studies. I cite them in political science studies. I cite them in my report. If you have an interest in making distinctions between ID laws, this is a distinction that you will occasionally find in the literature: strict, non-strict, relying on the NCSL data set. And you even will find in one of the articles that I cited, at least, that these distinctions will sometimes be characterized as ID required and ID requested states. So strict states would be states where IDs are required, whereas non-strict states would be states in which IDs are requested because there's a way to vote and have your vote counted without actually showing ID.
And how does the National Conference of State Legislatures categorize SB 824?
It's non-strict.
And do you agree with this categorization?
Yes, it's consistent with their definition.
And to take another of the voter ID laws depicted here, how is Indiana's voter ID law categorized?
It's categorized as strict.
And under Indiana's voter ID law, can a voter get a free ID without showing any documentation?
No.
And how does that compare to SB 824?
Under SB 824, it's possible to get a free voter ID without showing any supporting documents at all.
And under Indiana's voter ID law, can a voter with a disability use that as a reason to cast a ballot without having a valid ID?
No.
How does that compare to SB 824?
You can certainly cite disability as a grounds for not presenting ID, and you can vote a provisional ballot and have that ballot counted without any further action.
And are you familiar with the U.S. Supreme Court's decision addressing a constitutional attack on Indiana's voter ID law?
I am.
And what was the outcome of that case?
The Crawford upheld the law, the Indiana law, and found, among other things, that the law was reasonably connected to legitimate state interests of combating fraud, promoting or safeguarding confidence in elections, and modernizing elections.
Turning back to SB 824 and your review of it in this case, to what extent do the IDs allowed in SB 824 show a pattern of preference for IDs held by white voters?
I'm sorry, could you repeat the question, Mr. Patterson?
Yes, I'm sorry. And my question was, to what extent do the IDs in SB 824 show a pattern of preference for IDs held by white voters?
So I review the 8 forms of ID. I review 8 forms of ID that are not universally accepted by photo ID states. All states accept driver's licenses and passports, but I review the roughly 8 forms of ID that are not universally accepted, but that North Carolina accepts. What I find is that there are a number of forms of ID that North Carolina has accepted that other states have rejected, that are more likely to be held by African Americans than by whites, or more likely, or in some cases, more likely to be held by racial minorities generally than by white voters. So this would be inconsistent with the expectation of a pattern of preference for IDs that are held by disproportionately frequently by white voters. So, for example, out of the universe of employee IDs that might qualify, that might be compliant with a voter ID law, the General Assembly only permits the use of government employee IDs, specifically local and state government employee IDs. And what do we know about public sector workers in North Carolina? What we know is that African Americans are more likely to be employed in the public sector in North Carolina than whites. So this is an example in which we find the General Assembly choosing one set of one sector of employee IDs, and African Americans are overrepresented among government employees in North Carolina. Now, about 10% of government employees in North Carolina are federal employees, and federal employees may not use their IDs. The vast majority of government employees are local and state. Federal employees may not use their ID in North Carolina. We don't have racial demographic data on federal employee ID holders in North Carolina. What we do know is that nationally, white Americans are more likely to be federal employees than are African Americans. Another example that I look at is college student IDs. In North Carolina, African Americans and Hispanics are more likely to be college students than they are to be registered voters, which is to say they're overrepresented as compared to their representation on the voter registration rolls. They're overrepresented among college students. So this would be another form of ID that fits poorly with the hypothesis of what you might call a surgical precision hypothesis, where you're preferring forms of ID held by whites disproportionately frequently. Another form of ID that I look at is, yes.
I didn't mean to interrupt. I thought that you had finished your answer there. It's 11 o'clock and time for us to take our morning break. Hopefully we can come right back to that when we come back at 11:15. We'll be in recess for 15 minutes. Thank you.
Thank you.